Today I'm in London to talk to you about intellectual property escrow agreements. I'm standing outside the Bank of England because for many the Bank of England represents security for their assets, much like what you want for an IP escrow account. IP escrow agreements are being heavily used today in commercial technology contracts. The way they work is this. Let's say that you provide infrastructure to a city like London. Say it's telecom or trains. And you need me to build the computerized systems for those projects. Well, you'll need to service and upgrade those projects for many, many years, decades even. To do this, however, you'll need my assistance. You're of course concerned that someday I'll not be able to provide that assistance to you. So what do? Well, you could buy the IP from me, but that could be very expensive, and you may not really know what to do with it. So the solution is to put it in a safe place, everything that you're going to need to build the project in the event that someday I can't provide the service. That's where the escrow comes in. The basic framework is to deposit everything the customer will need to manufacture the product without the manufacturer's assistance. That means patents, copyrights, software, designs, schematics, trade secrets, processes, everything. In any IP escrow contract, there are basically 4 big issues to tackle. 1. Who pays for it? 2. Who selects the IP escrow company? 3. How do you confirm that the IP escrow deposit is complete? And 4. Under what circumstances can the customer access the IP? The first question as to who pays for it. This one is relatively simple. If the customer wants the IP escrow, the customer should pay for it. Bargaining power can of course change this, but generally speaking, it's the customer that pays for the escrow because the customer wants it. Second, who selects the IP escrow company? This one is more complicated. Why? Well, think about it. The customer is going to want the IP escrow to be close to them so they can access it. But the manufacturer is going to want it close to them so that they can control it. There's really an easy way to realize what the end solution should be, and that's this. Think about what's going into the IP escrow account. Trade secrets. The treasures of the manufacturer. Generally speaking, there is no way that the manufacturer wants that to be too far away from him. He's going to be nervous enough about depositing it with a third party to begin with, let alone moving it geographically far away from him. But nervousness aside, there's a practical reason why the IP escrow company should be close to where the manufacturer is located, and that's this. The deposits that go into the IP escrow account, it won't be just one. It should be several. There will be the initial deposit, and then as time goes on, you may realize that more needs to be deposited. The geographic closeness of the IP escrow company to the manufacturer makes it easy to make those deposits. And even if there's no mistake made, there could be upgrades to the system. Those upgrades need to be deposited into the IP escrow company as well. So, on the whole, the IP escrow company should be close to the manufacturer geographically. For the final 2 issues, however, you need to have a little faith, which is why we're now outside of St. Paul's Cathedral. How do you confirm that the IP deposit is complete? Remembering that we're likely dealing with highly technical information, patents, trade secrets, voluminous objects, or source code, this can be very difficult. The customer will need to prepare a detailed list of what it wants in the deposit. He'll have to coordinate that with his own technical people, as well as the technical people of the manufacturer. And he'll have to actually negotiate how much of it he can actually see, because the manufacturer may not want to share the trade secrets with the customer. The reality is that many companies never complete this process. They never actually know for certain if what is in the actual escrow account is complete or not. They simply pray that it's complete, and they have faith in their business partners. Of course, if that were true, I'd be out of a job. The final big issue is under what circumstances can the customer access the IP. These are known as triggering events. Usually it has to be something very serious, like a natural disaster or the company's bankruptcy. But you see, here's clearly where the details matter. For example, let's take the bankruptcy example first. In many countries, a bankruptcy court won't let the customer access the IP because the IP has value. And that IP can be sold to satisfy the debts of the manufacturer. So even if you have a contract that says that the customer is entitled to that IP, a bankruptcy court could very well overrule that and not let them have access to it without extra consideration. Another example is the natural disaster or a war type situation. And here's where we come back to that issue about where the actual IP is stored, the geographical location. Because if there's a natural disaster at the manufacturer and the IP escrow is in the same geographic location, well, it could be that the IP escrow company has the same kind of problems. Earthquake, tsunami, things that wipe out whole geographic regions would be a similar problem. So careful drafting of these triggering events is critical. Now, a really sticky triggering event is what to do when there's a breakdown in the relationship between the businesses. Oftentimes, this will be because of a material breach. Now, the reason that this becomes difficult is because what is material? How big of a breach do you have to have before you can go ahead and access the IP that's in the IP escrow account? You see, the manufacturer is going to want to keep the event very, very large. Like the manufacturer just for no reason decides to stop manufacturing. But the customer is going to want different types of circumstances. I've seen triggering events as small as the customer not approving who the subcontractor was, or any kind of delay in the manufacturer's performance. In my opinion, this goes too far. But I can see the customer's point. A secure flow of vital components is critical. On the other hand, you really have to watch out for some kind of veiled grab at the IP by the customer, where he can use any reason to steal your IP. The next time you consider an IP escrow agreement, keep these rules in mind, pay attention to the details of the triggering events, and you may have something of value to both parties in the long run. Thank you.